I want to mention 2 or 3 cases, simply because it's less boring for you to have actual stories rather than theoretical principles being discussed. I want to mention a few cases which I think were of particular importance as background to the Act. One was an education case, a sex discrimination education case, called Equal Opportunities Commission against Birmingham City Council. Now, this was a House of Lords case. The Equal Opportunities Commission is an administrative agency, or was, which has strategic law enforcement functions. It can take up important cases, it can represent individuals, it can issue non-discrimination notices, and so on. The particular problem in Birmingham was that girls do better than boys at every level of exams, that being true, of course, across the world now. And they were doing so well in Birmingham that where there was selection for the good state schools, more girls than boys were qualifying to get into the state schools within a particular, or rather state-funded schools, in the state grammar schools in Birmingham. And so the Birmingham Education Authority handicapped the girls in order to secure, because they said, we haven't got enough places. The boys' schools are more numerous than the girls' schools. We inherited these different schools. Therefore, we have to limit the number of able girls. So a really borderline but good girl, who is brighter than a borderline but good boy, was denied entry to the grammar school. And so they were sued by the administrative agency for gender discrimination, for direct gender discrimination. But for the girl's sex, she would have got into full-sex grammar school. And the Birmingham City Council said, but this is ridiculous. We simply inherited a system of schools where there are fewer places, there happen to be fewer places in the, for girls than boys. We had no intention of discriminating against the girls at all. This is just a historic consequence of the education system. But the House of Lords said, it doesn't matter what your intention was. What matters is a matter of causation. But for the fact that Mary was a girl, would she have got into as good a school as John? Whatever your intention. And they therefore required the Birmingham City Council to build another school, which they did, so that there were equal number of places on non-discrimination in access to those schools. That was followed by another case, which racked intelligent judges up and down our system, and continues in a way still to be controversial. This was a case called James and the Eastleigh Borough Council. The Eastleigh Borough Council, a local authority, decided that it would help elderly people like me by allowing them access to their swimming pool if they were of pensionable age, which was 60 for women and 65 for men at the time. And they could get in and swim without having to pay. Whereas if they were below the age of 60 for women or 65 for men, they would have to pay 50 pence. Mr. James was 64 and Mrs. James was 64. So Mrs. James would get in free because she was the pensionable age for women. But Mr. James was not able to have to pay 50 pence because he was not yet of the pensionable age for men of 65. So the puzzle was, what kind of discrimination is that? Is it direct discrimination or is it indirect discrimination? And the reason why the judges, especially in the Court of Appeal, led by one of our ablest judges, Lord Brown Wilkinson, classified it as indirect, I think, is because they thought that the local authorities should have the opportunity to justify the policy that they were putting forward, whereas if it was direct discrimination, there would be no opportunity to do so. When it got to the House of Lords, the House of Lords by a majority decided that it was direct discrimination. What was that argument really about, I think? It seemed to me that it was a classic case of direct discrimination and not indirect, because if you were comparing the man and the woman, Mr. and Mrs. James, but for Mr. James's sex, he would have got in free. But the other way of looking at the case was to say, well, they were both being treated equally in a formal sense. You had to have pensionable age to get in free, and therefore it was a classic case of indirect discrimination. And I promise you that the simple fact of that case caused more intellectual difficulty than many others, and continues to do so. In fact, one of Lord Walker's cases that he has mentioned, brought forward here, is a good example, the Elias case, of what I think is a muddle in our Court of Appeal, still about these concepts of direct and indirect. At any rate, when we came to do the Equality Act, the 2010 Act, what we did, how much longer should I speak for? How much longer? Well, I could go on all day, so how much longer do I need to do that?
45 minutes.
How long have I had? 10 minutes more. You see, in the House of Lords, if you speak for too long, they yell out, too long. And in the House of Lords, if you read too much, they yell out, reading. So I'm trained to not to be too long if I can avoid it. Anyway, in the Equality Act, I mean, in essence, we have moved from a model which relies on individuals to bring cases of discrimination to a model which places more obligations on public authorities and employers to promote equality and eliminate discrimination. That is one of the major changes we made. We came to the view that if you rely purely upon individual cases, even when backed by a body like the Equality Commission, that is arbitrary. It's not a systemic approach to systemic problems of discrimination, and that you need the administrative agency to be able to bring before courts systemic problems, important problems, but you also need to place upon those in a powerful position in our country to have positive duties to eliminate discrimination. So that is one major shift that we made in this legislation. We also rationalised all the concepts. So if you want to know how we dealt with concepts of direct discrimination, indirect discrimination, victimisation, harassment, it is all set out in the Act and in these wonderful explanatory notes. We extended the law in order to give effect partly to European law. We extended the law to a series of what we call protected characteristics. And the protected characteristics are age, a particularly difficult thing to deal with in legislation, age discrimination, disability discrimination, gender reassignment discrimination involving transsexuals, marriage and civil partnerships, where we have under our Civil Partnership Act a proper system for gay couples to register and be treated as in the same way as married couples, pregnancy and maternity, race, religion or belief, sex, and sexual orientation. And one of the great problems which Colin O'Connor, who worked with me, knows particularly well, is the problem of how you fit religious discrimination and sexual orientation discrimination together within the same statute, since right-wing religious groups regard homosexuality as evil and wish to be able to differentiate on that basis, and the conflict between religious groups and gay and lesbian individuals and groups gives rise to great tensions, which we try to reconcile within our equality legislation. One thing which will interest you particularly here is, of course, since 1960, the migration of Indian, Pakistani and Bangladeshi migrants to the United Kingdom, producing very significant minority communities, about 2.5 million Muslims, about 800,000 Hindus and Sikhs, roughly speaking, has brought with it problems of its own within those minority communities. I'll be talking in the later session about the problem of forced marriage and how we have tried to tackle that in recent legislation. But another problem has been one of caste discrimination. And before the enactment of the Equality Bill, there was a large movement among the British Indian population to include caste discrimination as part of the conduct made unlawful. I know that it's a subject that will come later, but could I just say at this stage that there is in this Act a power for the Minister to add caste discrimination as a subcategory of race discrimination and make that unlawful too. And at this moment, ministers are agonizing about whether or not to exercise the power. Obviously, there are political implications, since they would be worried about offending British Indians in the ballot box if they made caste discrimination unlawful, and there was some kind of backlash against it. So there might be unworthy political considerations at the back of some people's minds. But there are also other problems as to whether it's divisive to allow litigation, civil litigation, where people allege that they've been treated unfavorably, less favorably, because they are not members of a caste. And you, of course, have dealt with caste discrimination in your constitution in a particular way. You've dealt with it in your criminal law in a particular way. I don't think you've dealt with it in your civil law in a particular way that would happen under our equality legislation. But one major difference between you and us is that we view fundamental rights entirely as individual rights. You view them, to some extent, as collective rights. You permit what we would call quota reasoning in some of your jurisprudence. Take, for example, the Supreme Court decisions in the St. Stephen's College case and other cases, the other cases that followed it, where you decided that it was okay to have a quota to protect a Christian minority in those schools. I forget whether the 50% quota or what it was. Anyhow, that's what you decided in those two cases. Now, we have turned our face against quota reasoning. We, of course, allow positive action in carefully defined circumstances. We prohibit indirect discrimination. But what we do not do is to permit quotas in the way that I think your system does. And there was an important case in the Privy Council called Tengur, T-E-N-G-U-R, and the Bishop of St. Louis, Mauritius. I appeared in the case in the Privy Council, Lord Bingham presiding, where an attempt was made by the bishops to rely upon your Supreme Court case law to justify a quota in Mauritius in favor of the Catholic Church, so that half the places in state-funded secondary schools could be allocated on the basis of religion, and the other half on the basis of ability. And we looked at the Indian jurisprudence and also the European Court of Human Rights jurisprudence. And we discovered that the Mauritius Constitution, drafted by Stanley De Smith, the great Stanley De Smith, the author of the great De Smith on judicial review administrative action, he, having drafted the Mauritius Constitution, deliberately rejected the Indian model with the notion of collective rights in favour of the notion of individual rights, basing himself on the European Convention system, which is modelled on the notion of individual rights. And the Privy Council unanimously came to the conclusion that the Mauritius Constitution did not allow quota reasoning, and therefore they couldn't reserve places in their state-funded schools to protect the Roman Catholic minority. Everybody had to be treated on an equal basis. And I mention that because it's important in a colloquy of this kind to identify issues of principle which go to the heart of our systems. And I think that is one of several major differences. Another, of course, being that under our system our judges are much more restrained than yours in what I would call running the country, because our parliament is much less restrained than yours in solving problems. And we also have a much clearer separation of powers, although you poor judges have had to fill the gap which your politicians have left vacant, and therefore, because somebody has to solve the problems, you have to do so. But that's another major and here is a very good example. You poor judges may well have to develop, through case law, a lot that's in this statute, because the idea of the Lok Sabha producing anything like this in your lifetime is improbable. So all I can say is I hope that reading the explanatory notes on the Equality Act will be something that will interest you, and I hope that you will find what I said, although everything else is going to be more interesting and relevant. I hope that whoever is the least interesting and relevant may not be myself. And thank you very much. Thank you very much.
Well, friends, the next part of the program is to have a discussion, and the time available with us is half an hour. So I would like the participants, if you have any questions to Lord Lester or to me, or they have their own comments on either of the presentations. Hopefully, whoever is making the point will make it in a short time, so that everybody, I mean, at least those who want to say something also get some time. Well, there is a suggestion from the organizers that we'll listen to Lord Walker first on the leading decisions on equality and non-discrimination. He's a judge from the Supreme Court of UK. I think that will be better, and then we have the discussion on all the three presentations thereafter. I suppose all of you agree? Okay, so may I request Lord Walker to make his presentation.
May I say very briefly how wonderful it is to be here, and I'm very, very grateful to be invited to attend this colloquy. I think what I have to say follows on fairly naturally from what Lord Lester has been saying, but in my case I'll be moving really from the general to the particular, because I want to concentrate on just three recent English cases, looking at them in a fair amount of detail. They are difficult cases. You may think that some of the analysis is a bit technical, but I think that they do throw out some of the general problems that Lord Lester has mentioned in and also that Justice Keeler has mentioned in his opening remarks. I will try not to repeat general points that Anthony Lester has made already, and that applies in particular to the general European framework of the English discrimination law, and also to the distinction between direct and indirect discrimination. But I shall certainly have something to say about that, because it is very important indeed in the English jurisprudence. And I hope in turn that what I'm going to say will not preempt too much what our two distinguished academics, Professor Castellino, are going to have to say this afternoon. It's a bit like, I think, what sportsmen indulging in the more vigorous contact sports call getting your retaliation in first. But the three cases I want to talk about are Carson, Elias, and the Jewish Free School. Miss Carson is a case that was decided by the House of Lords in 2005. She was a woman who had gone in retirement to live in South Africa, having spent her working life in England and having paid taxes in England during her working life. Her complaint was that she got an English old age pension paid to her in South Africa, but she was deprived under English legislation and regulations from receiving an annual cost of living update that was paid to all UK resident pensioners, and was also paid to some non-resident pensioners with whom the British government had negotiated a reciprocal arrangement to that effect. But South Africa, in common with, I think, Australia and New Zealand as well, places where many British pensioners live, had no such reciprocal arrangements. Her claim failed in the House of Lords. She then took it to Strasbourg, and it failed there twice, because it went first to the Ordinary Chamber and then on appeal to the Grand Chamber in Strasbourg. So that's the first case that I want to look at in some detail. The second one is the case of Mrs. Elias, which was decided by the English Court of Appeal in 2006 with no further appeal. Her complaint was, in her own graphic words, that she was British enough to be interned by the Japanese in Hong Kong during the war between 1941 and 1945, but not British enough to be compensated under a scheme which the British government introduced belatedly in the year 2000. And she failed in her claim based on direct discrimination, although she succeeded in a claim based on indirect discrimination, and the case is of considerable interest in the borderline, I shall suggest the rather vague borderline between those two sorts of discrimination. And the third case is that of a schoolboy referred to as M. He was 13 years old at the time. His father was referred to as E. And E brought a claim on behalf of himself and on behalf of his son for judicial review against a very well-regarded and very successful Jewish school in North London called the JFS, which means Jewish Free School. And because his son was refused entry to that school, since it was a school that was allowed, it was called a faith school, it was allowed to discriminate in favour of Jewish boys and girls, but they took the view that E's son M was not Jewish, because according to the office of the chief rabbi in London, he didn't meet the rules for being recognized as an Orthodox Jew because his mother had been converted to Judaism, not in an Orthodox synagogue, but in a synagogue in Italy of another branch synagogue. So their claim was heard by the Supreme Court in London in a case that attracted huge attention by 9 justices. And the justices were split. 5 held that it was direct discrimination on racial grounds, because I should have said the faith school was entitled to discriminate on religious grounds. It was not entitled to discriminate on racial grounds. So the point at its simplest was whether to say, in the eyes of Orthodox Jews, sorry, you're not a Jew, was to discriminate on religious or on racial grounds. So of the 9 justices, 5 said that it was direct discrimination, 2 said that it was indirect discrimination, 2 said that it was not discrimination at all. So it is a case of considerable interest and considerable length, because the 9 judgments together run to 295 paragraphs. Now, before I come on to those 3 cases, I'd like to touch on a few general points, although I shall try not to repeat anything which Anti has covered already. He has explained how English discrimination law is very strongly influenced by 2 separate streams of European law. That is both the European Union with its court at Luxembourg, which has, starting off with legislation affecting working conditions, has gradually extended its legislation until it covers discrimination in almost every field. And the other is the European Convention on Human Rights with its court at Strasbourg, which is hugely concerned with discrimination law under Article 14 of the European Convention on Human Rights. Article 14, whose text I'll read in a moment, as interpreted by the Strasbourg court, is has a very wide scope. Lord Hoffman commented in the Carson case that it's very nearly as wide as the 14th Amendment to the Constitution of the United States, equality before the law, which is conveniently also Article 14, I think, of the Constitution of India. What Article 14 of the European Convention says is that it prohibits discrimination in the enjoyment of convention rights on any ground such as sex, race, colour, language, religion, political or other opinion, national or social origin, association with the national minority, property, birth, or other status. The words "or other status" at the end of Article 14 have been interpreted by the Strasbourg Court as broadly equivalent to personal characteristic. They certainly extend to sexual orientation and to marital status. In one recent English case, if I venture to quote what I said, personal characteristics is not a precise expression. Its personal characteristics are more like a series of concentric circles. The most personal characteristics are those which are innate, largely immutable, and closely connected with an individual's personality: gender, sexual orientation, pigmentation of skin, hair and eyes, congenital disabilities. Nationality, language, religion and politics may be almost innate, depending on a person's family circumstances at birth, or may be acquired, though some religions do not countenance either apostates or converts. But all are regarded as important to the development of an individual's personality. They reflect, it might be said, important values protected by Articles 8, 9 and 10 of the Convention, that is the right to private life, the right to freedom of conscience and the right to freedom of expression. Others, I said, other acquired characteristics are further out in the concentric circles. They're more concerned with what people do or with what happens to them than with who they are, but they may still come within Article 14. So the scope of Article 14 is very wide and perhaps a bit vague at the edges. So the reach of the European Article 14 is wider than Article 15 of the Constitution of India, which is well known to all here present. Its text has been quoted already, so I won't repeat that again, except to say that it does, I note, prohibit discrimination against citizens on grounds only, I emphasize that word, on grounds only of religion, race, caste, etc. Now I'd be interested to hear in the discussion what weight, if any, the Supreme Court of India has put on that possibly important word only. Under Article 15 of your Constitution, Ms. Carson, I think, would not have been able to establish a claim under the article. Mrs. Elias might have done better because of the reference to place of birth. I'm not going to begin to guess how the schoolboy M would have, whether he would have fared better or worse under your Article 15. The Strasbourg Court has been fairly slow to recognise the concept of indirect discrimination, although it certainly does now, but it's relatively late. As a matter of history, indirect discrimination has been much more important in English legislation, both under influences from the United States, and I think that Lord Leicester, in his time when he was working with Roy Jenkins, looked a lot at some of the American jurisprudence, and also under the influence of directives from Brussels, of the European Union, which is, of course, being concerned in the first instance with rights of workers, has naturally been concerned with indirect as well as direct discrimination. In 2000, the EU Council issued a directive, the Race Equality Directive, which expressly prohibited indirect as well as direct discrimination on grounds of racial or ethnic origin. And that directive, as transposed into UK law, defined indirect discrimination by reference to, and I quote, an apparently neutral provision, criterion or practice which would put persons of a racial or ethnic origin at a particular disadvantage compared with other persons unless that provision, criterion or practice is objectively justified by a legitimate aim and the means of achieving that aim are appropriate and necessary. Now, that is rather a cumbersome definition. It's much more easily explained by examples. The seminal American case of Griggs and Duke Power was a case about an employer adopting an apparently neutral practice of requiring all applicants for employment to take a written aptitude test. But in fact, for social reasons, black American applicants for the job found it much more difficult to do well in the written aptitude test than whites. And the Supreme Court of the United States held that in fact this was discriminatory because in its result, and it could be justified only if taking a written aptitude test was really necessary for the job. And as the jobs were predominantly manual jobs, they decided that there was no sufficient business necessity to justify this practice, which as a result, although not formally, was unfair to black applicants. Another example, which I think Tony Lester may have mentioned already, but which is common all over the world, is the practice of employers in offering less favourable terms to part-time workers than to full-time workers in terms of pensions, holiday pay, and almost anything else you can think of. Now, that is apparently neutral. The distinction is, are you a full-time worker or a part-time worker? But in practice, all over the world, it is women who are mostly part-time workers because of their responsibilities as child bearers and homemakers. And so offering unfavourable terms to part-time workers is perhaps the commonest example worldwide of indirect discrimination. And there's another sort of where you look not at the proportion of those who are affected, but whether some people are much more severely affected than others. To give a simple example of that from an English case, there was a school which had a rule, and whether it invented the rule for the purpose or not, that no boys who went to the school could wear any hat or headdress. Well, for most it was a matter of complete indifference, because they didn't want to anyway. But to a Sikh boy seeking to go there, it made all the difference. And so that was another example of a neutral and apparently neutral provision which operated unfairly. I wish to stress, although Lord Leicester's mentioned it already, that the borderline between direct and indirect discrimination is not a matter of mens rea, because it is perfectly possible for direct discrimination to result not from any particular individual malevolence, but simply from that's how the system works. And the Birmingham City Council case about the girls' school and boys' school is a very good example of that. It just happened when the Sex Discrimination Act first came into force. No one intended to be unfair to young women, but it was unfair to young women, and it was direct discrimination. Conversely, although many examples of indirect discrimination may again be something that just happens, there are one or two quite worrying cases in England where I have the very clear impression that civil servants and their political masters have got well on board the fact that direct discrimination can never be justified. Indirect discrimination can be, and when it comes to drafting the text of primary and secondary legislation, they sometimes seem to me to say, well, let's make sure if it is discrimination at all, it's indirect, and then we have a fallback position. And in fact, the Elias case is quite a striking example of that. There's just before I leave Birmingham and the very interesting question of individual rights and collective rights, Birmingham were required to see that there were equal number of places for girls at grammar schools as for boys. Arguably, they should have been seeing that there were even more places for girls than for boys, because it is a fact that in most countries, once the educational facilities are there, that teenage girls show more aptitude for studying hard and not being distracted by other things. And certainly there was a case in Hong Kong recently where